Welcome to the Appellate Division, First Department virtual oral arguments. We are now in session. I will begin with a call of the calendar. People versus Michael Adams is submitted. Perez versus City of New York. Appellant Perez gets 5 minutes and one in rebuttal.
Thank you, Your Honor.
City of New York gets 5 minutes. GR Children is submitted. Cabrera versus Thomas is submitted. Al Abdi versus 281 St. Nicholas is submitted. People versus Jose Justiniano is submitted. Boski versus Levine. Appellant Boski gets 7 minutes and one in rebuttal. And then respondent Levine gets 4 minutes. Herrick Feinstein gets 6 minutes. Morik Haack gets 4 minutes. And Mazar gets 4 minutes. People versus Trilroy Peterson. Appellant Peterson gets 5 minutes and one in rebuttal. People get 5 minutes. Doe versus Intercontinental Hotels. Appellant Doe gets 6 minutes and 2 in rebuttal. The hotel respondent gets 4 minutes. Denalo Construction versus Phoenix RMA. Appellant Phoenix gets 6 minutes and 2 in rebuttal. Respondent Denalo gets 6 minutes. People versus Walker is submitted. Galena versus MTA Capital. Appellant MTA Capital gets 5 and 2. Cross Appellant Galena gets also 5 and 2. Wright versus Carroll in Riverbend. Appellant Wright gets 6 minutes. HPD and Riverbend respondents each get 4 minutes. 30-32 West 31st Street versus Hina Hotel. Appellant Hina Hotel and Cross Appellant 3032 West 31st Street each get 5 minutes each, only with respect to appeal number 2931. Actually, that's the case number. The appeal number is 13484. The second case regarding the motion to strike the expert's testimony is submitted. Last case is Worldwide versus Cargo Cosmetics. That case is submitted. For the record, Justice Kapnick is recused. Justice Marty Shulman has been vouched in on that case. Okay, first case on the calendar for argument is Perez versus City of New York.
Good morning, Your Honors. Jillian Rosen for the plaintiff appellant. Can you hear me? Okay.
Good morning.
Good afternoon, I mean. Sorry, good afternoon. Can you hear me? I just wasn't sure if my microphone was working.
204. So it's good to see you, Ms. Rosen.
Okay. Thank you. You too, Your Honor. Your Honor, in this case, we do not dispute that the notice of claim was deficient. But here, under 50-E6, for amending the notice of claim, the operative criteria is prejudice. And here, it was a mistake to dismiss the complaint because the defendant absolutely did not establish any prejudice. In fact, they didn't even establish that they undertook an investigation in this case. In the summons and complaint and in the bill of particulars, the plaintiff claims or alleges causation, alleges, affirmative creation. And so they can't deny that they were on notice that this would be an affirmative creation, an exception to the pothole law case. But what's really exceptional, I think, in this case is the lack of prejudice.
isn't the city arguing that basically they are prejudiced because now they have to redo the investigation, basically to deal with all of the new theories that you're now alleging, including cause and create of the hazardous condition. The city hire inadequate and incompetent help is what's being alleged now. That wasn't in your original notice of claim, was it?
No, the original notice of claim, it wasn't, but in the summons and complaint that was served a month after the notice of claim, the plaintiff alleged affirmative creation, cause and create, and it was also amplified in the bill of particulars. But importantly, at the 50H, which was only 2 months after the notice of claim, the plaintiff testified extensively about the location of the defect and exactly where this happened and the size of the hole. And what is an issue here, which they can't show prejudice, is because there actually was a subpoena served on a non-party, and this is at 152 of the record. There was a permit that was issued by the DOT to a non-party for it's either construction or rehabilitation of the Riverside Drive viaduct that was issued 5 months before this accident. And there was a lot of motion practice and court orders that arose out of plaintiff's attempt to obtain documents from the city of New York, because this Riverside rehabilitation project covered the accident location, exactly under the viaduct where plaintiff fell in this hole. So our position is that the city, the key to all of this is in the city's hands. The city never produced the documents despite a so-ordered stipulation and a court order to do so, and that the controller's office knows whether they either affirmatively created it or had prior written notice of this. But
Ms. Rosen,
yeah.
aren't there cases that say from our department that the plaintiff cannot rely on the 50H hearing testimony to rectify the deficiencies in the notice of claim? I mean, I hear what you're saying about the prejudice, and I understand that, but how do we get around our prior case law?
Well, because of the summons and complaint that we pled in the summons and complaint, cause and creation, that and actual notice. So I understand. I mean, as we know, I don't have to tell you this, that the purpose of the notice of claim is to preserve the area for an investigation while the facts are fresh. And here we have a situation. I think that Judge Kennedy is speaking to me, but
yeah. I'm no longer muted. We fixed it. Thank you, Ms. Rosen. You talk about the summons and complaint that you alleged that the city caused and created, but in paragraphs 23 and 27, you only indicate that the city was negligent in maintaining the accident location. So how does that give notice about a cause and create?
Well, because I think that given the testimony of the plaintiff at the 50H in connection and in conjunction with the fact that there was either construction or an inspection that occurred at this location 4 months prior. So this information was provided in opposition to the defendant's motion. By the way, the defendant waited 4.5 years to move to dismiss our complaint and proceeded and charted their litigation course to litigate this case up until then, and then moved to dismiss. But in response to that, but even before that, this subpoena went out because there was evidence from a permit that either rehabilitation or construction was going on. So I think that if you look at the defective notice of claim, there's no question, but if you look at the summons and complaint, the bill of particulars in connection with the 50H, and the fact that the defendants cannot deny that there was either rehabilitation or construction going on at the very site that they know about, but they haven't produced the records to us. If we got the records and it said we weren't doing anything at your location, we didn't create this, we had no knowledge of this, or under Bilecki, it was something that was wear and tear, then we wouldn't institute, we're not going to, institute a frivolous case, but they're holding the key. That's
let me hear from the city.
Okay. Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the court. This is Philip Young on behalf of the City of New York.
So I was going to ask this of Ms. Rosen, so I'll ask this of you. She made her initial argument was prejudice. It's really fundamental. where exactly does it state that prejudice is a sole determining factor, as she stated? I thought this was more in terms of a defect of the notice of claim and subsequent pleadings.
You are correct, Your Honor, and that's the first point I was going to make. The operative criterion here is not prejudice. There are two elements for Section 50E6. The first element is that there has to be, the amendment is limited to correcting a mistake, omission, irregularity, or defect, and does not amount to a substantive change to the theory of liability. Only if you pass that first step do you get to the question of prejudice. And this court very clearly held in matter of Corwin that if the motion to amend the notice of claim contains material that goes beyond correcting a simple mistake or defect, then the question of whether the city would be prejudiced by the proposed amendment is irrelevant. So,
okay, so we're not going to consider prejudice, which I don't think is an issue at this point in time. So why is it now that the notice of claim, 50H, et cetera, would not put you on notice, put the city on notice of exactly what the plaintiff was referring to in terms of the defect?
well, Your Honor, the notice of claim complaint 50H testimony did not put the city on notice of plaintiff's new theory of liability, which is affirmative negligence. In their notice of claim, they never pled prior written notice or an exception to the prior written.
I understand that they only, claim a negligence theory, and then they later raise the cause and create, which the question is really, does it change the nature of the claim pursuant to a precedent, right? I mean, I heard Ms. Rosen argue that at the 50H hearing, the plaintiff went all over the nature of the defect, how he was, apparently he had been skating in that area before and had not seen that kind of defect. So why were you not on notice just from that and the additional bill of particulars?
Sure. So a couple points on that. So first, on the 50H testimony, there's nothing in that testimony that relates to anything, any actions that the city performed, any affirmative city conduct that caused this pothole. Everything is in terms of the plaintiff's personal experience running over the pothole. There's nothing that would put the city on notice in that testimony that plaintiff was alleging affirmative negligence by the city that caused the pothole. The bill of particulars, the city does concede that alleges affirmative negligence. That's the first time it was raised. And it wasn't raised until 3 years after the accident took place, after the statute of limitations had passed. And so it didn't provide the city with the type of advance notice that it needed in order to conduct an investigation here when, the accident scene is unchanged and memories remain fresh. And then third, the reason this is a substantive change to the theory of liability is for the reasons that this court laid out in its previous decision in Alexandrova from 2017. So in that case, this court distinguished its earlier decision in Cook. And in Cook, what plaintiff had done is that in addition to their failure to maintain allegations, they had also alleged an affirmative negligence repair job. And this court said that that was sufficient to allege cause and create or affirmative negligence. And in Alexandrova, this court contrasted those allegations with what it had in Alexandrova, which were purely failure to maintain allegations. And the same is true here. The only allegations in plaintiff's complaint are failure to maintain allegations. Paragraph 23, paragraph 27 throughout the record. I think it's record pages 38 to 40. So for that reason, this proposed amended notice of claim amounts to a substantive change to the theory of liability. And then one quick additional point I want to make on the discovery issue that opposing counsel raised. I believe she was misrepresenting the record there. In November of 2019, Supreme Court issued an order specifically stating that the city was not required to produce these documents. And the reason it wasn't required to was that the Supreme Court found that these documents were irrelevant. And the reason they were irrelevant is because all of the documents and work at issue related to an inspection performed by an engineering firm of the the viaduct that holds up the Hudson Henry Parkway. It didn't have anything to do with the actual roadway beneath the viaduct where the accident took place. So plaintiff's assertion that these, the city's possession of these documents and failure to produce them raises an inference that the city had all the information it needed to conduct an investigation and may have been affirmatively negligent is simply not true.
Okay. Thank you, Mr. Young. Ms. Rosen, you get a minute.
Okay, Your Honors, just quickly, the Corwin case that my adversary cites is actually in my favor. It's 141 AD 3rd 484. And just like here, it talks about the city not being prejudiced when the plaintiff amplified the claims in the amended notice of claim because the city was in possession of relevant facts and documents and had access to former employees involving the facts of the case. Here, actually, I think one of the justices asked me about this, and I would like to point to Cruzado against City of New York, which is 80 AD 3rd 537, which was where this court held that prior written notice is not a new theory of liability where prior pleadings allege actual notice, which is what our summons and complaint did. With regard to the court orders, my understanding of the record, and I think I read every page of the record, is that the last order that I saw from the court actually amended.
So you think, I'm sorry, so you think that the complaint talking about the road, referring to the road as broken, cracked, defective, loose, bulging, put the city on notice of the defect?
Yes, in my summons and complaint, which was amplified in the bill of particulars and
Right.
exhaustively discussed at the 50H.
And in the bill of particulars is where you raise the cause and create the hazardous condition, right?
Your Honor, I believe it is in the paragraphs that were mentioned in the summons and complaint. I know my time's going to run, so it's in the summons and complaint as well. One last point to my adversary about these orders. This project covered the accident site, and the last order that I have in the record, which is 199 of the record, was where the trial court amended its order and left it to the city to decide what was confidential and what was not. The city claimed that some of these records were confidential and they didn't want to provide it. There was going to be an in-camera inspection. So the court adjourns it and gives the city more time to comply and puts the date to September 30th, 2019. That's at 199 of the record. Now, coincidentally, or maybe not coincidentally, that's the exact date that the defendants moved to dismiss. So at this moment, this very moment, we don't even have an answer as to whether these documents, which hold the key to the answer, to the question as to whether the city either affirmatively created or had notice of this hole where there was either construction or rehab going on in this area, and it still hasn't been disclosed by the city.
Okay. Thank you, Ms. Rosen.
Okay, thank you.
Thank you both.
Thank you very much.
Next case for argument is Boski versus Levine.
Yes, may it please the court, Stephanie Feldman on behalf of appellants Stuart Boski and Alan Hermes. Yes, at its core, Your Honor, the trial court below improperly applied the standard to dismiss the complaint pursuant to CPL Law 3211A. According to that provision, a court must take all the allegations in the complaint as true and resolve all of the inferences in favor of the plaintiff and all the favorable intendiments and afford every favorable inference, even if the complaint is not artfully pled. Basically, if there's any inference or interpretation under which an applicable statute of limitations could be told, dismissal should have been denied. The court did not do that below.
When do you, just regarding the legal malpractice claim?
Yes.
When did that? I mean, when did you get the legal services from Mr. Levine? And let's put aside whether he was a Harry Feinstein or he had moved to another firm. When do you claim those legal services were provided?
Appellants claim that the legal services were actually provided throughout this entire period. Appellants initially went to Levine, whom I will point out was the chair of the tax groups at both of the law firm respondents, first at Herrick Feinstein and then at Moore, Hawk and Hamoff. And they first first had these services in 2002, and those services continued. Levine continued to render advice.
But in 2002, we were just talking about structuring the investment, right? So you're saying that's the legal advice that you're talking about?
No, we're talking about, actually, Your Honor, we're talking about the legal advice that continued into the formation, the management. Levine was also serving simultaneously through 2015 as the tax matters partner responsible for all of the strategy LLC and investment vehicles. So that continued throughout.
Ms. Feldman, was there any break after approximately 2005 until when the Department of Taxation and Finance sort of made you aware, or at least made the defendants aware, allegedly, of the problems that they were having with this particular tax structure? Was there a break in legal services for some period of time there?
We do not believe that there was a break in services. In fact, there were continuous emails, communications, and the like throughout that period. And during that period, Levine also served as the tax matters partner and would continue to advise and counsel the appellants on these investment vehicles as well. So we believe that there was a continuous time and that there was no break in that representation.
He was the tax matter partner for at least one of the LLCs, particularly the one that got involved with the tax litigation, sort of the test case, the big one that they were that the litigation got involved in. So he was the tax matter case for that. And the plaintiffs, if I understand, were partners in that LLC. So was there continuous, back and forth as to what they should do, and advice is what you're saying? And is that alleged in the complaint?
Correct. That is alleged in the complaint. There's instances of advice and communications in each of the years in question. I'll also point out that in terms of the actual malpractice, that under the applicable standards, even if this court were to hold that there was an act of malpractice stemming back those years, acts to attempt to rectify any act of malpractice serve to toll that statute and serve to continue that statute of limitations beyond that initial act. So under either interpretation, whether the clear allegations of the complaint show this continuous flow of communication, but also those acts could also have the inference of being acts to mitigate and rectify these acts of malpractice, which even if the court below limited its analysis to only the initial investment in the strategy and the formation of these investment LLC vehicles. But even if the court were to take to draw that conclusion, which we argue is improper, the fact that there were additional communications, advice on how to structure them going forward, advice on the IRS and the New York State Department of Taxation and Finance notices, how to dispute them, advising on not to accept settlement offers and the like. These could also
he was paying for that advice, did he not? I mean, I know that you alleged that there was a payment for that advice. I think in May of 2008 is when you sent payment to Levine and Harry Feinstein to file a response to the state audit, right?
Correct. Payments were made, and also, as alleged in the complaint, payments were made throughout all the respondent firms throughout this time period, as alleged, and also in as late as 2012, as alleged in the complaint, there was a convincing of the appellants to contribute $50,000 each into Herrick Feinstein's trust account in order to fund and litigate this IRS notice and this tax determination that these strategies LLCs were invalid. So those fees go throughout the time period as late as 2012, and as alleged in the complaint, these fees continued to be paid throughout this time period.
Okay, so it was in September of 2012 that Mr. Levine moved to Morit Hawk, right?
I believe that, yes, I believe that that's as alleged in the complaint, and but he continued to serve as the tax matters partner for this particular
Levine did. The question is, where was he, and whether that can be imputed to any of the other defendants, right? He was at Eric Feinstein, but as of September of 2012, he had moved to Morit Hawk, right?
Correct, Your Honor. Correct, Your Honor. I'd also like to discuss the allegations, the claims of fraud, which the court also dismissed. There are numerous reasons.
I'll give you 30 seconds for that. You're running out of time.
I understood, Your Honor. Well, in that case, in terms of the allegations of fraud, multiple grounds exist for the sustaining of those under the.
I mean, my question is really, when did that cause of action for fraud accrue? Is it in 2002 and 2004 when you enter into the allegedly fraudulent transactions, or was it later? But I can let you answer that in rebuttal. Okay?
Yes, but we understood, Your Honor.
Thank you, Ms. Feldman.
Thank you.
Okay, let me hear from Mr. Levine.
Your Honor, Joe Kernan for Harold Levine. The defendant submitted a request to slightly adjust the order of the presentation, which the court approved. So that approval.
Oh, I see. I didn't think it was the order. I thought it was the amount of time. So who's going to go first, Eric?
Herrick will go first.
Okay, so Herrick has 6 minutes. I apologize for that. I thought Mr. Levine will go first and then Herrick Feinstein will go second. But I allocated 6 minutes to Herrick Feinstein. So,
right, and then Mart will go second. Levine will go third, and Mazurs will go fourth.
Okay, perfect.
So I'm going to mute now. Thank you, Your Honor.
Okay.
May it please the court, Gregory Joseph for Herrick Feinstein. Your Honors, as Justice Acosta pointed out, Levine left Herrick in 2012. It is undisputed that Herrick did not represent these plaintiffs after Levine left. Herrick never represented the plaintiffs in the tax litigation. There was separate counsel that did that. And being tax matters partner, as we pointed out in our brief, does not mean you need to even be a lawyer. The plaintiffs themselves were tax matters partners in two of the other LLCs. It was in 2017, 5 years after Levine left Herrick, that they filed suit. There is no conceivable timely malpractice claim that can be asserted against Herrick.
I'm sorry. Go ahead, Barbara. Go ahead.
No, please, Your Honor.
Well, I was going to say, Levine was the person that they turned to, that they knew. I think he was recommended by Mr. Katz, who was their longtime accountant, and they kind of got Mr. Levine and the plaintiffs together. And didn't Mr. Levine serve as an attorney to represent them? And even though I know Mr. Levine was not the attorney in the federal case, it was Mr. Dix that was representing them. Mr. Levine was the conduit and was their connection to them. They really had very little connection to Mr. Dix. And to suggest from all the emails that I've seen that there was no legal advice being given during that time, I think is a little not accurate.
I mean, in fact, just to supplement that, I mean, in May of 2008, and this is why I mentioned the payment that was sent by plaintiff to Levine and Herrick Feinstein to file the response to the New York State audit, right? And how to structure the response. You know, I know there was correspondence, for example, August in 2008. after receiving the IRS notice of deficiency, plaintiff emailed Katz and Wissel Mazar asking for, how do we respond?
Your Honors, I was not addressing what Mr. Levine did before 2012. I wanted to make it clear because of what counsel argued. There was no representation in the tax case itself. It did not, everything ended in 2012. The case is filed in 2017. There's no tolling for a legal malpractice claim. There is no conceivably timely claim against Herrick for whatever claims the plaintiff may have after 2012. So there can't be continuous representation.
So anything that accrued after September of 2012, you're saying basically Morit is the one on the hook.
Or Levine, but it's not Herrick. And what's important is that these plaintiffs are on inquiry notice of their fraud by their own pleadings 10 years before they filed suit. In 2007, they plead that New York State issued a notice, which they plead was for transactions similar or identical to their tax strategy. And they plead that New York State said in this notice that it has determined this transaction to be a tax avoidance transaction and intends to challenge any purported tax benefits from such a transaction or a substantially similar transaction. And they allege this was a similar transaction. That's
but Mr. Levine's response to Mr. Bosky was, they don't know what they're talking about, basically, the state, right?
It's true that there are continued assurances. That does not constitute continuous representation. It may be a separate, if Mr. Levine said that. Okay. Again, if they're still on notice, on inquiry notice, the same year, New York State says it's a tax avoidance transaction. The IRS says it's a transaction of interest, and they plead this means the IRS has determined that it could have the potential to lead to tax evasion. In 2008, the IRS denied 30 of the $33 million deductions claimed in the RERI transaction. By 2014, the U.S. attorney sued Levine for 90 unlawful tax schemes. They still waited 3 years, eating up the entire 2 years for fraud, for the window for discovery for fraud. They can't claim a fraudulent concealment. You can't plead fraudulent concealment when you're on inquiry notice. And they did not dispute the untimeliness of the claim against Herrick. They complain now the dismissal was with prejudice, but they did not even present a defense to the motion to dismiss. You can't leave a claim dangling to try and extort some settlement value. They did not defend at all on that claim. Their constructive fraud claim doesn't even give the benefit of the 2-year window. But let me talk about their funding of the RERI tax case, Justice Acosta, because you raised that issue.
Okay.
That began in 2008. Now, cause of action for fraud accrues at the time you make the initial investment, not each time that you continue to invest based on the same assurances. They already are on notice that while Levine is saying this is a legitimate tax strategy, New York State and the IRS are saying this is an illegitimate tax strategy.
Right.
That is inquiry notice. They say it wasn't until 2016 when there was an indictment they had inquiry notice. That was an indictment for defrauding Herrick.
Right.
But there's a difference between the fraud claims and the legal malpractice claims. And doesn't Mr. Levine continue to tell the plaintiffs that I think we have very strong legal arguments here, and I think that the state, there's a lot of weaknesses in their case, and they kind of discourage them from actually entering into any of the settlement proposals that were proposed to them by the state because they were giving them advice suggesting that, don't settle. This isn't a good deal. We can get a better deal, or, I don't think they have a strong case.
And Your Honor, that is all happening after they're on inquiry notice and more than 6 years before he's leaving, more than the 5 years before he leaves Herrick. What I'm saying is that Herrick is out of this picture in 2012. They claim there's a failure to supervise. That ended in 2012. They had until 2015 for fraud. If there was a fraud, why did they continue to litigate this case for 2 years after they filed the suit?
Okay.
They continue to
That's a
litigate
fair
the tax
question.
case.
That's a fair question. Thank you, Mr. Joseph.
Yes.
Mr. Kernan, you going to argue for Levine?
No, he said Mark's next.
Mark,
okay.
next. We'll go after.
All right.
Yes. It's
I
Paul.
missed the order.
Yes, good afternoon. It's Paul Weinstein from Morit, Hawk, and Hamroth. Good afternoon. In addition to the arguments that were made by Herrick, which included that that these claims accrued long ago in the early 2000s and were long barred by the time this case was brought, Justice Branston was completely correct when she analyzed what the specific allegations were when Levine was at Morit Hawk. And she went through what the allegations were, and she was completely correct in that there were no allegations while Levine was at Morit Hawk that anything he did based on these allegations were deficient, caused harm, or would have affected the outcome. So she analyzed them individually. They were emails that were at best keeping the plaintiffs up to date as tax matters partner on what was going on in the litigation. They were separately represented by another counsel in that litigation, and these were just update emails. So in analyzing each one on whether they constituted malpractice, in addition to the statute of limitations arguments, and that the claims were barred for that separate reason, she looked at the actual claims about the events that took place when Levine was at Morit Hawk and determined independently that they failed to state a cause of action. And she was completely right. There's nothing alleged there that were more than update emails from another lawyer. There was even a specific reference that you should talk to your lawyer, which wasn't Levine. It was Randall Dick about what's going on.
So you're saying that there was no advice regarding the tax litigation after September of 2012?
I'm saying two things. There was no advice, but there was no malpractice. There was nothing wrong with it. It was just, see an accountant. Here's an update on the litigation.
What about the fact that the plaintiffs did make payment to Mr. Levine while he was working at Morit Hawk to continue or to keep the litigation going, the tax litigation going? And also, what about the advice that I believe came during that period of time about not settling the case? Plaintiff said, you know, if I knew all the problems, if I realized what was really going on, I may have settled the case in a different way. But weren't they advising him not to settle the case? And wasn't that something that was, you know, that was strictly illegal advice?
Okay, two things. One, I do not believe that there are specific allegations about payment. The payment in 2012 that was discussed was at Herrick. Now we are assessing.
I'll look at 170 of the paragraph 170 of the complaint. I'll look it over again, but I think it does say it was made there.
Okay. My understanding is that allegation and the emails with Randall Dick were about the payment or a request for payment while Levine was at Herrick, and that there was no payment afterwards. Now, on the advice, any discussions, first of all, this case was going on for a very long time before Levine was at Morit Hawk. And it was when the plaintiffs were represented by another attorney. So any discussions that Levine would have had about that case had to have been as tax matters partner, not as a lawyer. And it also wouldn't have affected the outcome, as Justice Branston noted. The case had been going on for a very long time. Discovery had taken place over
But it couldn't have been as his accountant, right? Because part of the allegation is that between 2014 and 16, Mr. Levine advised Mr. Bosky in response to inquiries to speak with his accountant to calculate potential losses, right?
Yes.
So Mr. Levine, as a lawyer, is telling check with your accountant. So is that legal advice?
Well, I'll say this. Levine was Tax Matters partner. So he was essentially like a partner with the plaintiffs in a sense. And he was discussing the case with them on that basis. Because they had their own lawyer to ask advice of, Randall Dick, not.
But wait, but they just. But I thought that the plaintiffs allege that they did not go out and get Randall Dick. Mr. Levine said Randall Dick is handling this, and I thought, you know, they did not independently choose him. So he was just somebody that Levine and Katz found to represent him, and I thought Levine was sort of still acting as a conduit.
Well, I'll say two things about that. That was many years before Levine joined Moore Hawk. When that case, when the Riri case was commenced. So Moore Hawk would have nothing to do with that and wouldn't know about that. But the bottom line of it is, these were sophisticated plaintiffs, and Randall Dick was the lawyer. So if they wanted to know and get advice on what to do in that case, they would speak. The
problem is, Mr. Weinstein, that in a 3211 context, you want us to examine and decide as a matter of law, basically, what the nature of each of the relationships were. And usually that's not the posture in which we make that decision. But having said that, let me go on to the next lawyer. You're already being on for 6 minutes. You want 20 seconds to answer that?
Yes, I do.
Go ahead.
When the allegations themselves are examined, nothing that Harold Levine is alleged to have said was alleged to have been mistaken or wrong. If anything, at its best, it would have been a comment upon past malpractice, which under settled case law is not a new act of malpractice.
Right.
It's not a new act, so that Moore Hawk cannot be responsible.
Handling this issue. I appreciate that. Thank you, Mr. Weinstein. Next.
Yes, thank you, Your Honor. Joe Kernan for Harold Levine. Briefly on the fraud and specifically the discovery rule, New York law is clear, and this is from the First Department. The 2-year discovery period commences when circumstances are such as to suggest to a person of ordinary intelligence the probability that he has been defrauded. That's the Azura Bank versus Credit Suisse case.
Well, that's Mr. Bosky, right?
That
reasonable intelligence.
Well, no, I don't think Mr. Bosky and Mr. Hermes are of ordinary intelligence. We have a certified public accountant, a lawyer with an LLM in tax, who are both senior executives of a global real estate firm. And so we have people of extraordinary intelligence, experience, and education. And the red flags that have been pled would have put a person of ordinary intelligence on notice that there's a potential fraud here. They're burning red flags for these extraordinarily intelligent and sophisticated plaintiffs. When in 2007, when the New York State issues its notice of listed transaction, someone with an LLM in tax and a certified public accountant knows exactly what that is. It says right in there, no valid business purpose, no economic substance, all the tax benefits are going to be challenged. A few months later, the IRS gets involved, issues the same notice. As is pointed out by counsel for Herrick, in the next year, $30 million in deductions are disallowed. And in June 2014, the U.S. attorney's civil complaint against Mr. Levine accused him not just of promoting 90 illegal tax shelters, but using companies with phony losses on the books, and that he told lies about tax benefits of transactions. Not a good thing to be accused of that, don't get me wrong. And this action
So when do you argue the fraud claim accrued? Back at the beginning, back in 2002 and 4, or later on?
Back at the beginning, Your Honor, but under the most favorable view of the complaint as alleged, and trying to take advantage of the discovery rule. By the time Mr. Levine is accused by the U.S. Attorney's Office of using companies with phony losses on the books and telling lies about tax benefits on tax shelter transactions, these highly sophisticated plaintiffs are on notice and on inquiry notice, and their fraud claim is time barred. Briefly on the malpractice, I think it was Your Honor who asked, was there any break in services between the early time and the later time? The counsel said no, it was continuous. That's not true. The court below found there was a 3-year gap, and look at the papers. There's no allegation of specific continuing services in that 3-year gap. It's too long a gap. They don't get to rely on continuing representation, and the malpractice is time barred for anything that happened in the 2002 to 2004 time period. Now, Mr. Levine is alleged years later to have become re-engaged and have communications with the plaintiffs. No doubt about that. But let's take a look at those communications. Mr. Levine sends an email April 2011. If the IRS contacts you, tell them you were represented by counsel, Randall Dick. Mr. Dick himself wrote to the appellants same month, April 2011, and said to the IRS, the following individuals, and he named the 2 appellants, are represented by me, and the appellants were copies of them. Mr. Levine never entered an appearance in any case on behalf of the plaintiffs. There's been no allegation of that because we know it's not true. In 2013, Mr. Dick sent an email to the appellants and said, get caught up on your payments, because if you don't, I will, quote, resign from your representation and will tell the IRS, close quote. And there are other examples in the papers where.
But wasn't, even if there was some contact directly with Mr. Dix, there was still emails from Mr. Levine to the plaintiff saying, don't reply if you get this, you should ignore this, do that. He was still giving them legal advice. They could have more than one lawyer just because Mr. Dick was the one representing them in the tax case. Seems to have been a lawyer, a legal relationship with Mr. Levine that was ongoing, notwithstanding the existence of Mr. Dick.
As tax matters partner, he's obligated to interface with the taxing authorities, relay information to the partners. And I think that one email you're referring to, Your Honor, is what to do if the IRS calls. If the IRS calls, call Mr. Dick, call your lawyer. He said, don't tell them to call me, call your lawyer. When they ask about what is this going to potentially cost in settlement, ask your accountant. I'll pass it on to the accountant. It's classic relaying of information, which is exactly what the court below.
But he also was relaying information about possible settlement negotiations and saying, don't accept that. We think that there's a lot of weaknesses in the IRS's case. We think that they're, we stand strong here. I mean, I think that's legal advice. Who else is going to tell you that there's weaknesses in a case if it's not a lawyer?
Well, he's also partners with them in the same transaction. He's referring to Mr. Dick at every turn. And the emails, if I were a client, emails that were received by these appellants from Mr. Levine consistently deflecting and say, talk to Mr. Dick, talk to Mr. Dick, talk to your accountant, talk to the tax lawyer at Mazars. There was never a response saying, wait, you're my lawyer. You're my lawyer. There's no allegation to that. There's no email response where the accountants ever dispute Mr. Levine consistently pushing them on to their counsel and to their accountants.
Thank you, Mr. Kernan.
Thank you, Your Honor.
Okay, next.
Yeah, Your Honor.
Could barely hear you.
I'm sorry. This is Ira Greenberg representing Mazars. First, let me point out that the facts relative to Mazars are fairly undisputed. They filed the tax return with the deduction taken for the year 2004. There is nothing again about Mazars' involvement until 2008 or 2009. There is nothing in the record, in the complaint, about advice that Mazars gave after the initial filing. The only paragraph of the complaint that details what Mazars communicated is after 2004 is paragraph 91 And it says that a Mazars partner, Whistle, conveyed a settlement offer. There is nothing that says that Mr. Whistle or anyone else at Mazars said, don't take the settlement offer. Mr. Katz left Mazars in 2009. Whatever Mr. Katz may have done after 2009 is not attributable to Mazars. Now, going to Justice Kapnick's question about a break earlier, we pointed out that in 2004, everything that was done with respect to the filing had already been done. There was a break because the next involvement detailed in the complaint of Mazars is in 2009. The continuous representation document requires continuous services with respect to the specific matter at issue, and there has to be an explicit contemplation of further representation at the time of the initial retention. That's in the Court of Appeals case, Williamson versus Price Waterhouse. The mere possibility of possible later services is not enough. That's in this court's Johnson versus Proskauer Rose decision. And as Justice Branson cited the Landau case, Landau versus Snowbecker Krause, a long gap defeats the continuous representation doctrine. So what we have here is we have services that ended in 2004. 3 years later, the claim with respect to those services is gone, and whatever happened thereafter is not actionable. Let me make one more point, please, if I may.
Well, Mr. Greenberg, when in May, let's see, August of 2008, when plaintiff received the IRS notice of deficiency, he emailed Mr. Katz, Witzel, and Mazars, right? Asking how to respond. So why do we make that? Is he asking for legal advice? Is he asking for something else?
It's not clear what he's asking for, Your Honor, but what is clear is, A, there was a gap between 2004 and 2008, so it's a new representation, and B, there's nothing in the complaint about a response to that request. So even if it was asking for legal advice, and remember, Mazars is an accounting firm, not a law firm,
Right.
even if he's asking for legal advice, it doesn't show continuous representation. And there's no indication that there was bad, in quotation marks, legal advice given then. Because while the complaint alleges that Mr. Levine and other people gave legal advice that may or may not have been erroneous, there's nothing in the complaint that says anyone at Mazars gave legal or accounting advice after the last filing that may have been erroneous.
Okay. You have one last point to make, Mr. Greenberg?
No, Your Honor, I think I've made my last point. Thank you very much.
Thank you. Okay. Back to Mr. Bosky.
Yes, Your Honors, a lot to unpack.
1 minute, Ms. Feldman.
Yes, a lot to unpack here, so I'll make it brief as I can. First, with respect to Herrick Feinstein's arguments regarding inquiry notice, that is distinctly not the case here. In fact, as you know, inquiry notice relies on if it's reasonable for them to have inquiry notice. Once again, it cannot be emphasized enough that this is not an arm's length transaction. These are their trusted lawyers, their trusted accountants, they're tax experts. Levine was the chair of the tax department at each of these firms. They specifically, I'm sorry, Your Honor?
Who is the one who has the LLM in tax?
But the point is, Your Honor, but even if they have an education,
sophisticated parties, you're trying to portray your client as this, you know, this appellate division judge who knows nothing about this kinds of transactions.
even if there's an educational background, this was not their profession. They were not experts in the fields of very sophisticated and complicated tax investment strategies. This was on a level involving multiple investors, multiple platforms, multiple entities, and nonprofits and the like. This, appellants were real estate related professionals. This was not their area. So to say that they were supposed to be on notice and in fact put the burden on them to question their own tax lawyer's advice is an improper shifting of the burden. In fact, in the complaint itself, appellants state and allege in the complaint that that they only found out about these issues when during the RERI tax litigation, when they were called upon to testify, both Levine and Katz invoked their Fifth Amendment privileges and didn't testify as to the questions as to what due diligence they even did to form these investments. And again, as the court needs no reminding of, these are two individuals who were then later indicted and later convicted of crimes involving the same
Can I ask you one question, Ms. Feldman? Mr. Joseph said way back when he spoke that Mr. Levine was at Herrick Feinstein until 2012. This case was not commenced until 2017. So forget, I'm not talking about the fraud case, but on the legal malpractice claim, I mean, is it just too long? Did you wait too long to bring this legal malpractice claim against Herrick Feinstein? Because after Mr. Levine left, Herrick Feinstein never represented your clients. The representation went along with Mr. Levine to Morit Hawk, but Herrick Feinstein was out of the picture in 2012.
Mr. Levine was then not a partner at Herrick Feinstein after 2012. That is correct. But in terms of the statute of limitations being continued, the statute of Herrick Feinstein should not be able to escape the statute of limitations and that tolling based upon the breaches of its own fiduciary duty. What did Herrick Feinstein know and when about the defalcations of Mr. Levine, the fact that he was subject to both civil and criminal cases by the United States Attorney's Office? Why did they not inform all of their clients? The appellants weren't clients of Herrick Feinstein. Why did they not state that, by the way, a former chair of our tax department is now indicted on fraud of our firm and for perpetuating the same type of illegal tax schemes of which you fell victim? I'm sorry, Your Honor?
Thank you, Ms. Feldman.
Thank you, Your Honor.
Thank you all.
Thank you.
Thank you, Your Honors.
Thank you. Okay, People versus Peterson.
Good afternoon. May it please the court, Shana Watrous on behalf of Mr. Trilroy Peterson. Mr. Peterson's conviction was based entirely on witness testimony, and there was ample reason to doubt that those witnesses actually saw what they said they did. And there's a plausible explanation for what actually happened here that didn't involve Mr. Peterson.
I know that you talk a great deal about the inconsistencies in the testimony of the different police officers, but those inconsistencies were fairly minor, were they not?
No, Your Honor. You have the inconsistency of how.
There was one. How far was the backpack from the victim? What does that difference? 2 feet, 3 feet, 4 feet? I mean, what's undisputed is that your client went through the backpack, pulled a phone out, looked at it, obviously wasn't of enough value, put it back in, and clearly there was a larcenous intent.
Well, I would just note.
Go ahead. I'm sorry. Go ahead.
I would note that actually on the point that you just mentioned about it being undisputed that he pulled the phone out, actually the jury chose to discredit all of the officers that said that happened, and actually found that was not credible and acquitted him on that count. But no, these facts go directly to the core of the allegations against Mr. Peterson. They were all over the place on whether the crime was already in progress when they came upon it, or whether
Counsel, I'm sorry. I was intrigued by your statement a little while ago that there is a plausible explanation or a plausible alternative to exactly what occurred. I'm curious, what would that be?
So the complainant was sleeping for multiple stops prior to getting into this station. And he also says that there was something missing from the bag that was not found on my client, his co-defendant, or on the ground in the car of the subway train.
No property was actually taken to be found on on your client or any of the other defendants. So that doesn't really matter. I mean, they didn't actually take property and place it on their person. But I'm sorry, continue.
Right, but what I'm saying is that the fact that he had been sleeping and that he didn't see what happened and something was missing indicates that it's at least possible that there was somebody else who, prior to the train pulling into this station at a prior stop, because he had been sleeping for at least 2 stops, had actually done this, pulled the bag out and looked through the bag.
And so that would be pure speculation that would be nowhere in the record, because the complainant, although he was sleeping, did testify that when he fell asleep, he had the bag between his legs. He had a strap on his knee, I believe, so that if there were any movement, he would feel it. And then when he was finally awoken by the police officers, the bag was away from him. It was no longer between his legs, and the bag was in fact open. And in fact, that occurred after the police officers observed your client and the other defendants rummaging through the bag.
I would just note that...
Was that not what the testimony was?
The testimony was that when he fell asleep, the bag was on his, sort of resting on his lap.
And also the testimony from the officers was that when they first observed the complainant, as well as your clients, the bag was between the complainant's legs. So you're saying that at some point during his ride uptown or downtown, a mysterious individual, took the bag from between his legs, went through the bag, removed something from the bag, put the bag back between his legs, got off the train, and then your client and the other defendants did not do something?
No, Your Honor, because there is a question given the credibility issues of these officers who have dramatically different stories about...
But not all of was Police Officer Bartley and Sergeant Stewart's testimony that basically your client and the co-defendant were hovering over the victim at 3:15 in the morning in the A train?
That's what they said, but they also said that at the moment before they saw any of this, when they just saw my client, they labeled him from the get-go a perpetrator. And it's just a question of if this man came into the station with the bag already open, they saw these 2 men that they had decided were up to no good, put 2 and 2 together and made an assumption about what they had done. But I do want to move just very briefly to the second.
Yeah, I mean, you're way past your 5 minutes, but
okay.
I'll give you an extra 30 seconds.
Thank you so much,
Your
Your
Honor. Generous today.
Thank you, Your Honor. I do want to move to the fact that the trial court should have charged the jury to consider the lesser included offense of attempted grand larceny in the 4th degree. There was a view, and the jury should have been allowed to consider whether the movement of the backpack constituted the taking that was required in this case. Pulling a backpack a foot forward is sort of the equivalent of lifting up a jacket, reaching into a pocket, as in People versus Moran, where that is simply an attempted larceny. You also have matter of PRB, where the allegations are very similar, that it's pulling a backpack away from a complainant without permission, looking inside it, and then eventually it gets returned when the complainant...
Are we talking about from the person? Are we, in all those cases, are we not talking about from the actual person? And we're not talking about from the person?
Sorry, Your Honor?
Are we, in those cases, is it not larceny from the person?
Yes.
The pocket, as opposed to here, where the backpack is not on the person?
Here as well, it's considered larceny from a person. And, matter of PRB, that was also, the boy had the backpack, it was pulled away, it was looked inside, and then that is considered attempted grand larceny. This court found that was attempted grand larceny. And this court is not being asked to find that it was attempted grand larceny, but rather just that the jury should have been able to make that factual call.
Thank you, Ms. Rogers.
Thank you.
Let me hear from the people.
Good afternoon, Your Honors. Jonathan Cantura for the people. Just as an initial matter regarding defendant's weight claim, that's partially unpreserved. The intent argument is a legal sufficiency argument. Defendant never moved for a trial order of dismissal, let alone argued that the evidence did not establish intent. In any event, there would be no reason for this court to address that. In the interest of justice, the officers collectively testified in a straightforward manner that they observed defendant acting as a lookout while his co-defendant White first took a cell phone, then took a backpack from between the legs of a sleeping passenger, slid it to the middle of the subway, and then they both rummaged through that property. That was clearly sufficient to accept.
Could you just address the lesser included issue first, please?
Sure.
What would the reasonable view of the evidence, or why would there not be a reasonable view of the evidence to sustain a charge of the lesser included?
Sure. As an initial matter, I would say that that argument is also unpreserved because it's a completely new theory that's being raised for the first time on appeal. But to Your Honor's question, the same evidence that establishes that defendant took the bag jointly with his co-defendant White establishes that he took the items contained therein. This is completely analogous to a wallet theft case, for example, where stealing somebody's wallet is the same as stealing all the credit cards contained inside. So the evidence that defendant stood guard by the train doors, looking up and down multiple times, two different officers testified to that, while his co-defendant put his hands on that bag and removed it.
But was the testimony of those two defendants totally discredited or not credited by the jury? That's what I heard Ms. Watros say.
Not at all, Your Honor. Yes, not at all, Your Honor. I mean, that's speculation on the part of the defense. The jury might have well been splitting the baby because the defendants decided to put the cell phone back, so we don't know whether it was based on their credibility. We do know that they convicted him as to this count, the theft of the backpack, and the evidence, again, established both the theft of the bag and the theft of all the items contained therein. So regardless of whether defendant specifically intended the theft of the bag or the items contained therein, the evidence was sufficient as to both.
So the larcenous intent could have just been inferred by the jury just from the mere taking of the bag from under the legs between the legs of the victim.
Yes, Your Honor, because the standard is exercises dominion and control over the property in a manner inconsistent with the owner's rights. Clearly, if somebody is sleeping on a subway, they don't expect someone else to take their book bag without their permission. And viewed in context,
they could have intended to permanently deprive him, although they wound up not keeping the bag, right? They left it a few feet or 15 feet. The testimony is equivocal.
Absolutely, Your Honor. And I would just point out that the victim testified that it was several feet away, regardless of what the officer said. But I would also point the court to its own case in People v. Ramos, a 2004 case, where it said that it's irrelevant that defendant later changed his mind and tried to return the item. That does not diminish the strength of the proof as to the initial intent to take the property from the victim. Unless the court has any questions, thank you.
I think we're good. Thank you, Mrs. Cantarero. Ms. Watros, you get 1 minute.
Yeah, I just want to reiterate that this should have been a factual question for the jury of, larceny does require movement, but not all movement constitutes the taking requirement in a case like this. And the jury should have been able to decide that whether or not that movement constituted the taking. We're not contesting that even under those facts, there could have been larcenous intent, but the actual taking itself was not completed. And this was, contrary to my opponent's contention, this was preserved fully at trial. The defense counsel said the taking was not completed. That's exactly what we are arguing here. And there was no more specificity required. The court decided on that point.
Okay.
Thank you.
Thank you. Thank you both. Doe versus Intercontinental Hotels.
Good afternoon, Your Honor. May it please the court. My name is Neil McGillivray and I represent the appellants in this matter. Your Honor, the only claim from the court below that is at issue here is the claim for negligent hiring, supervision and retention. And the lower court dismissed it on two bases. The first, for failure to state a cause of action, and secondly, on the basis of documentary evidence. Now, in terms
what about the claim that plaintiff makes that Ken's documentary evidence defense raised in the dismissal motion was untimely because it was not originally raised in the responsive pleadings, as they are required to do pursuant to CPLR 3211E.
Right, and Your Honor, I would say there that it's obviously you have an original complaint, you then have an answer shortly afterwards, you have a motion that comes 3 months later that's met with an amended complaint, then another answer, meaning an answer to the amended complaint, and then the original motion is applied to the amended complaint. But the motion itself, the return date of the motion is not until September 6th of 2019, which postdates both complaints and both answers. And obviously, that defense is not pled as an affirmative defense, which waives it.
But why does that matter? The fact is that 3211E doesn't really address whether it needs to be raised in the original responsive pleading, that may be addressed to a second amended complaint or something else. The fact is that, I mean, you didn't reserve it in the original pleading. If you thought that they were moving to amend or there were infirmities with the complaint, when you filed it or when you interpose the answer, you can reserve on that, right? But there was nothing said about it.
Judge, when you make the point to me in terms of my pleadings, obviously, Ms. Cherkas, I assume, will address what was reserved or not in her answers. But I think in terms
you're representing the plaintiffs on appeal.
I am,
right?
Your Honor. Yes,
okay.
plaintiffs, Your Honor.
The plaintiffs on appeal. Okay.
Yes,
so your position is that the motion court erred because the motion court should not have accepted this documentary evidence. Is that correct?
Correct, Your Honor. And to Justice Acosta's point in terms of CPLR 3211E, despite the answers, as it were, the motion post-stating the answers, the court did have the option to convert to a motion for summary judgment, but it didn't give notice to the parties.
But it didn't do that, right? And
no,
it didn't give notice.
It didn't. And in terms of the documentary evidence itself, I think there are many defects in terms of the presentation, but I think possibly the fundamental one is that it was presented in non-admissible form, in that it would not have met the standard for a motion for summary judgment, let alone a motion to dismiss, in that what you have here is you have an affidavit from an employee that's not at all based on personal knowledge, and he exhibits essentially certain documents from the security guard's employment file, but he doesn't lay any foundation.
This is where he spoke about the employee handbook, the fact that the employee was required to take part in a sexual harassment training program, don't sexually harass, and also the employee manual as well. So he did not, your position is that was in inadmissible form because he did not establish, for example, that it was a business record or that he had any firsthand knowledge of the employee actually having been given the handbook, et cetera?
Correct, Your Honor. Now, I would, in terms of that particular ground, meaning the documentary evidence ground.
What about the certification, though? Because that stood on its own, did it not? The fact that the employee was a certified security officer, or
Right.
was licensed or certified by the state of New
Yes,
York?
I mean, the thing is this, I don't know if that was necessarily presented in admissible form, but we wouldn't take issue with that. I don't think that advances, except for possibly the training aspect, which is not something we're pursuing in any event, but it adds nothing to the hiring, it adds nothing to the supervision or the retention as to the facts of this case. Yes, he was licensed and he may have undergone the state mandated training, but otherwise, again, even if we accept that particular document, that's the only document that's even arguably admissible.
And counsel, by the point that this motion was made, notwithstanding that we were already into the third complaint and there were 2 answers, there hadn't been discovery yet. There hadn't been depositions of the parties.
No, Your Honor, there was no discovery. I mean, again, a key point in all of this, there was not even a bill of particulars.
So how did we get to this point without any of this having been done? I don't understand procedurally. No discovery, no bill of particulars, and then automatically, and just initially there's a motion to dismiss for 3211?
Correct, Your Honor. That's essentially what happens, in that you have the original complaint, you have an answer, and then 3 months later, I mean, there are a number of defendants here, and there was an issue with regard to other defendants in terms of which was the correct entity. So that certainly delayed matters. But while that was going on, as it were, and that was the reason for the Second Amendment complaint, but while that was going on, the respondent here chose to, which obviously is its prerogative, to make the motion. But it's a motion that I think, whatever about the appropriateness of making it, it certainly should not have been granted. I mean, it's effectively a motion for summary judgment without any discovery.
All right. Okay, let me hear from the other side.
You're muted, Ms. Cherkis. You're muted.
Yes, Your Honors, Louise Cherkis for Kent Security. A variety of points here. First of all, as counsel was saying, there was a period of time in which other parties were delaying putting in answers, and when we what we did, we look at those pleadings, and the pleadings that are specifically addressed on appeal is that third cause of action, where there's nothing specifically pled with regard to sexual assault, and the case law establishes that just claiming the negligent supervision.
But they amended the original complaint 4 months later, right? The November 21st of 18 complaint was amended on March 22nd of 19, right?
Well, the only amended pleadings that were in existence at the time of our motion did not include anything with regard to that, specifically having to do with sexual assault.
When did you file your answer?
Our original answer?
Yes.
Our original answer was, oh gosh, that was like really early in the end of the year before. I think that was, I'm not completely sure without looking, but it was very quick. We filed it swiftly. Then they served an amended, because they were addressing with all the other parties. Then we served.
They really never changed the claims against your client, did they? The claims against your client were pretty consistent from the first complaint to the second complaint to the third complaint. Isn't that correct?
Yeah. That was the thing. They were consistent for us, and the point about it shouldn't accept a documentary evidence. The court has the right to to look at documentary evidence. And certainly we have the our contract with IHG,
But
which
isn't the
is one
argument,
of those other entities. Excuse me?
isn't the argument that the documentary evidence was not in admissible form?
I don't, well, I disagree with that it wasn't in admissible form.
Well, did he have any first-hand knowledge of any of the documents? The fact that the individual, the officer, the security officer had in fact received this?
Well, it identified that, well, what I'm saying is that the documents that have been in his, would have been, there's one thing about things being in his file. The other thing is Kent Security having a contract with IHG. That is Kent Security, you know, that is a documentary evidence in itself, which shows the limitations of Kent Security's job at the work site, which never, yeah.
Ms. Turkis, what about the point that I raised earlier, that the documentary evidence defense, we don't even get to the merit of it, because the fact is that you waived it because you did not raise it in your original responsive pleading. That's why I asked you, when did you file your answer? Because
well,
you never.
Okay, well, my position here is that at the time, I guess it's looking at future backwards, when we even taking that it had not been raised in the answer, there was by when there is a supplement, an amended complaint afterwards, it negates all pleadings that came before. It makes the circumstance such that it has to be considered it's like pre-answer, because.
So does it sound right to you that they filed on December 12, 2017, and then you answered on November 21, 2018, and although you asserted 14 affirmative defenses, none of them related to a defense based upon documentary evidence? Does that sound about right? But you do admit that in your answer, you did not assert any affirmative defenses regarding documentary evidence. Is that correct?
Yeah, in the record, yes. Yes.
Okay. So you just made a point about the contract. Are you arguing that the contract between, and I don't know why I'm yelling, is it that I've never had a person say that I speak too softly, but I don't know, maybe it's your thing because I'm yelling here.
I think it's
are you arguing that the contract between you and the hotel is such that it relieves you of all liability as to your officers? Is that what you're saying? Is that what I thought I heard you say? I'm losing my voice.
Okay, no, we're not. We are still in the case with regard to fraud claims having to do with the contract.
Did you make an argument concerning the contract between Kent and the hotel? What is your didn't you just mention something about that contract and somehow that had something to do with the officer? Is that what you were saying?
No, I was saying that the duties in our contract make it such that the claims, the allegations with regard to
never mind.
Mr. Teobach.
It's okay. Never mind.
Yeah.
Okay. Thank you, Ms. Shirkis.
Okay.
Counsel for Dole.
Yes, Your Honor, and I'll pick up on the last of Ms. Shirkis's points. I think the argument that she makes in her papers in terms of the contract is that it provides that Ms. Doe in this case is not an intended third-party beneficiary of the contract. And again, that's not in dispute, but it has nothing, it doesn't bear at all on the claim that is at issue, which is the negligent hiring, supervision, and retention. So whether or not the contract was presented in admissible form, it has no relevance to what's at issue here. And what is more, in terms of it's not simply that the initial answer that her client filed didn't contain the affirmative defense. They filed 3 different answers, one in November of 18, another in March of 19, and the third one in August of 19. They all predate the motion. And so even to the extent that the amended complaints, the first one and then the second one, supersede the prior pleadings once they're served, the problem here for a respondent is that they served and filed an answer in relation to the final, meaning the second amended complaint, and it was only after that. They noticed the motion beforehand, but they only in fact moved subsequently. And I would say, just in terms of the other basis relied upon by the trial court, I think it's quite clear it referred to or cited other lower court decisions in terms of whether the allegation as to what respondent should have known about its employee sufficed or not. It entirely conflicts with this court's decision in Goldfinger, and what's more, it basically is looking for a heightened pleading standard. It's far beyond it.
Counsel.
Just
you.
one.
Thank you.
I just wanted to say one thing.
Ms. Turkis, you don't have any rebuttal time. You didn't
Okay,
cross appeal.
that was an incorrect statement.
Thank you. Thank you both.
Thank you very much.
Denalo Construction.
Your Honor, my name is Alan Winkler. I represent Denalo Construction. The attorney for Phoenix RMA did not answer the clerk's calendar call, and apparently he's not online right now to argue. So as
the respondent, do you want to waive your 6 minutes, or, I mean, we don't need to, well, I'll let you decide, Mr. Winkler.
Thank you, Your Honor. So you beat me to the punch. I was speaking too slowly. What I was about to say was that unless anyone on the panel has a question for me, I will waive oral argument and agree to have this decided on submission.
Okay.
Wait, is that the attorney?
I think we're good. Say again, Justice Kapnick. Mr. Winkler is representing the respondent Denalo. Appellant.
No, I understand. Never mind.
Okay. Thank you, Mr. Winkler. I think we're good.
Thank you very much, Your Honor.
Okay, let me hear from Gallina versus MCA Capital.
You're muted, counselor.
Counsel for the MCA Capital.
I'll start over. Good afternoon, Christopher Simone for the defendants. Since the court found that the material room wasn't a passageway, for purposes of my appeal on the 1.7E2 issue, the only issue is whether—
What material room? Was there any testimony in the record that there was a material room?
Yeah, he testified this is the room where they kept material, page
But he didn't call it a material room.
Well, they asked him, so at the time of the action, were you in the material room? Yes. You were inside the material room? Yes.
But that's
Counsel,
the
if I may,
question of the
Counsel, if I may, I believe counsel asked that question. I should really say use that word 19 times.
Yeah.
The first time it even was brought up was by defense counsel. Plaintiff never said material room, never.
Well, Your Honor, he asked the question, material room, and he said yes. That's the same thing. What's the—
He wasn't. I think what we're all saying is it wasn't his thought at the beginning to say I was in the material room. People said, "Are you in the material?" Well, I was in the room where the material was. I mean, the concept that it was a material room seemed to have come from defense counsel and not from the plaintiff.
Well, Your Honor, there was no.
That's what we're saying.
It wasn't even a thought. It was a terminology. I mean, you know, and it was never expounded upon by anyone. Were you in a room where there was construction materials kept? It was nothing like that. It was always a reference to the material room. And so, you know, that's why I said there's nothing here that says that there was a material room.
Your Honor, if somebody testified, did you do something, and the person says yes, that's the answer.
Okay, well, let me.
This goes back to, you know, did you beat your wife? You know, it's the same kind of thing. You know, how many times did you beat your wife? You know?
Your Honor, I think that's the only thing that's not disputed here. This is a room where they kept materials. There was one door into it. He wasn't working in that room.
But
he
Count, Mr.
upstairs.
Simone, isn't there testimony that it from at least some of the people who were deposed or put in affidavits that said that this was a big construction site? Wasn't this the Second Avenue subway site? And wasn't there material that they put all over the place? There was some hole, and they lowered the material, some down here and some down here, and they needed material all over the place. So it wasn't like there was one room where all the material is. The material was up there, and they put it. They moved it to where it had to be through various holes and things like that. So the appropriate material was in the appropriate place.
Yeah, Your Honor, on a job site this big, I imagine there were several material rooms. I don't think the rule of whether something is a material room means there can only be one on a job site. The bigger the job site, I imagine there's going to be several material rooms. Doesn't change the fact that this room was where they stored material. That's the only purpose he was in it. He was in there to get his material to do his job.
Okay, so does that mean that it can't possibly be a passageway? Because there was testimony. I mean, it wasn't. I was not clear, speaking for myself, exactly what the room looked like and how it was configured. I know this was a very, very large construction site.
Well, let me first say this, if I may. I know the plaintiff's trying to kind of muddy his own comprehension here, but he was deposed 4 times. 2 of those depositions are in this record. He always expressed an understanding of English, never had a translator, never submitted any corrections. So even though his English might not be perfect, I think the testimony is clear. When he was talking about a walkway, he meant on the inside of the room, the material is stored on either side, and you walk in. From what I understand, it's a long room, but it's a big job site, so there's a lot of materials. But it doesn't change the fact there's one door here. You can't pass through this to go anywhere. And this court has defined, a passageway as a part of a building that leads to 2 different places. It leads through to something else. You couldn't do that here. It was a storage room. It was a material room. The Shield case dealt with a storage area. It was not a passageway.
Was there a description of the room that took place?
Pardon?
In this purported room, other than the fact that there was a door that was referred to. Is there any reference at all that's elicited other than the presence of the door itself in that area?
Well, I think it was open to the top so they could lower the materials into the room for storage.
No, but
so
anything else about the interior of the room? Anything else in terms of how it was laid out or how the quote unquote materials were kept in there?
I think he said that they were stored on either side and you walk through the center and the materials were there.
Were there pictures? I didn't think I saw them, but
I don't believe there were. No, Alex, you agree, right? There's no pictures. So I think that the court, I know we're going to have, Mr. Wool's going to speak on the passageway issue, but this was clearly not a work area. He wasn't doing work in this room. He was getting his bricks to do his work upstairs. He was working in another area. So I think
passing through.
He couldn't pass through this room. You couldn't go anywhere in this room.
But that was his testimony.
Yeah, you went in. Yeah, one door. I mean, that's what I understand. One door. One door is one door. You went in, you got your material, and you left.
Thank you, Mr. Simone.
Thank you.
May it please the court, Alex Waller for the plaintiff respondent. Your Honors, I really have not much to add on the passageway issue except to specify that the plaintiff himself referred to this space as a long, narrow corridor, a passageway, a walkway, and a hallway, and the safety contractor on the site, Mr. Mazza, also referred to it as a hallway. We cited cases from this court denying summary judgment, where the testimony was both by one witness, it was a room where materials were stored, and then by another witness, the plaintiff, that it was a passageway. At the very least, this discrepancy in the testimony creates a question of fact. And the fact that there's the problem with the with the defendant's motion is they complain about the record not being sufficiently developed regarding this room, but they moved for summary judgment. The burden was on them to make this record better if they could. And the fact that there was a door between one space and another, I'm not sure that that makes the door, that the door creates each space into a separate room that you can't go any further. It could be just a door for security purposes that divides a long, narrow passageway. So I think there's a question of fact on that issue. And as to the section E2 regarding the work area, the testimony is undisputed that the plaintiff worked for several days patching the wall with bricks. He said it took days and days. He had to go back and forth to this long passage where the bricks were stored to get his bricks. This court and others has held that that constitutes a routinely traversed work site, which makes it a work area. He slipped and tripped on, or slipped probably on a piece of debris and a scattered piece of material, namely a long electrical pipe or some sort. The defendant, again, being the movant, has not proven as a matter of law that this piece of pipe lying loose near the bricks was not scattered material, and for that reason, we think that the court was wrong on the passageway issue, but correct on the work site issue. I have nothing else to add.
Thank you, Mr. Ward.
Thank you.
Very, very quickly, to the extent that he described it as a corridor or a walkway, it's because this was a long room. But he explained that it's like a room, it's a room like that with the material on the side to side. It's a walkway, meaning you go in the room and the materials are on the side. That's all he meant by that. But it doesn't, the code deals with the function of the room, not the shape, not the size of it. Its function was a material storage room and nothing else. He wasn't doing any work in this room. Even though he had different jobs, there's no evidence to say that he was actually doing any work. He was going to pick up bricks. He had 15 of them in his hand. That's what he was doing. So he wasn't working there. And as far as the scattered debris,
it's a walkway, right?
Well, I think that what he's saying is a walkway inside the room because the material's on either side. You're not jumping over piles of material. You have to get in there to get the stuff. That's all he was saying.
It seems to me maybe you will ultimately win on this, but we're dealing with summary judgment, and it would have been nice to have a picture. They say it's worth 1,000 words. I don't know, but there isn't a picture. So, yeah, that might have helped clear it up.
I like pictures.
Yeah, and I know we're talking about a construction site, but my definition of a room, I need some kind of walls or something, that is surrounding the area. And again, as I said, I recognize a construction site, but can I get a wall or two walls?
I don't think there was any dispute that it was a defined space because they would lower materials from the top into it, and it had a doorway. So I don't think that's.
So why would that mean that it's a defined space?
Well, you said you wanted walls. I mean, walls can be different things. You can store materials. This is an underground project, not an above ground project.
No, that's what I said. That I recognize it's a construction site where we're underground in a tunnel.
But again, we're talking about
for some type of a room or a material room. I still would. I think there should be something in the record as to how it's defined.
Well, I mean, the code deals with the function. That's what the function of this room was.
Okay.
It was to store material.
Thank you, Mr. Simone.
Thank you.
You get 1 minute, Mr. Warwick. You good?
No, I have nothing to add on. Actually, one more thing, if I can. This court has also held that a passageway. My colleague is talking about function. That passageway can include a place where materials are stored. So I think we have it covered both ways.
Okay.
Thank you.
Thank you. Thank you both.
Have a nice day. Thank you.
You too.
Thank you.
Wright versus Carroll.
Good afternoon, Your Honor. I'm Melissa Perry. I'm appearing on behalf of appellants Janet and Dwayne Wright. Before I begin my argument, I'd like to request, is it possible to reserve one of my 6 minutes for rebuttal?
Yeah, I was surprised that as petitioner you didn't do that. I'll give you 5 now and 1 in rebuttal.
Thank you. Your Honors, this case is about Janet and Dwayne's home and whether they're able to remain in it. HPD inaccurately concluded that Janet and Dwayne do not qualify as family members under 28 RCNY 3-02P.
Yeah, I mean, I saw that. I mean, you had the hearing officer not really disputing the fact that this is a warm and close relationship that your clients have with Horace. I think that what they're saying, or what the hearing officer and HPD concluded, that you didn't have the required emotional and financial commitment and interdependence that's required going back to Brashi, right?
Sure.
So can you address yourself to that?
Sure, we would disagree with that. Specifically, there's 8 factors, and also the regulation 28 RCMY 3-02 directs courts or the examiner, the hearing officer, to look at the income affidavits and then also consider the 8 factors. We think that specifically they meet 6 of the 8 factors. They have a long relationship with Horace. They lived with him for over 5 years. 5 years is a long time, specifically for Dwayne, who was only 15 years old when he moved in with Horace. Some of the other factors are that they relied upon each other for household expenses.
Well, Counsel, if I may, this is Justice Kennedy. Now, I know that they submitted affidavits saying that they contributed to the household, but my question is, are there any receipts? Did they pay for any utilities, groceries? Because I don't see any documents to reflect that.
There's no evidence in the record that they did pay for any groceries or submit any receipts, but there is case law, specifically RHM versus Hampshire, that we would point to that says a lack of documentary evidence does not negate an applicant's ability to obtain succession rights. And
but there has to be, this is Justice Weber, I'm sorry. There has to be something. I mean, you don't have any receipts as to whether they paid utilities, etc. Also, they pointed to the fact that you had nothing concerning any intermingled finances or any ownership of any bank accounts, personal property, credit cards, any formalized legal obligations, health proxies, wills, powers of attorneys, etc. So exactly what did you have other than it was a close familiar relationship?
Of the 8 factors, we don't dispute that they didn't have intermingled funds. But with respect to the factor of sharing or relying upon each other for paid of household common expenses, we think that they fulfill this factor.
Wow.
Specifically, logistically, that they did rely upon each other to have the common necessities of life. Just
how do we know this?
A common sense perspective, they couldn't have survived. Horace relied upon Janet and Dwayne to live. He needed full-time, around-the-clock care at one point in his life, and that's what Janet and Dwayne provided for him.
Who paid for it, though? But again, I understand what you're saying, and it makes sense, because the claim was that he asked them to come to live with him, specifically Janice, I guess, to take care of him, and I understand all of that. But the statute does require certain factors, and you must meet certain factors. So
since I have limited time, I'll try to tick through them quickly, not to interrupt you. And then just to not give up on that point, there is a case, 532nd Avenue versus Zanker, which does say that they paint this picture of family life. And when it does paint this picture, the Zanker couple, they do talk about how they have this similar structure where she does do the laundry and the cleaning, and he does pay for everything. And so that is sort of a similar circumstances to the way that Horace and Janet and Dwayne arrange their life. But just because I have limited time, I want to try to address the other factors that we think that they fulfill. And so those are that they had birthday celebrations together, they celebrated Thanksgiving together, they celebrated Christmas together, they trimmed the tree, they celebrated New Year's together, they celebrated weekends together. They also held themselves.
Did they intermingle funds? Did they have a joint bank account?
No, we concede that they do not fulfill 2 of the 8 factors, one being
Counsel,
intermingled.
again, all you're talking about are familiar occasions. Obviously, if you live with someone, I would think, and you're talking about this relationship, you're going to celebrate Thanksgiving. You're going to celebrate Christmas. You're going to celebrate birthdays. I mean, these are all things that, yes, go to the familiar relationship, which I don't think there's any dispute. But what we're talking about are the other financial issues. And you mentioned 532nd Avenue versus Zenker. Even in that case, there was there was proof that there was a joint bank account, that there was a joint account that the tenant of record and the other individual had. And they drew from that joint bank account to pay utilities, to pay for the cable and the phone bills, to purchase groceries, etc. And I don't see anything like that here.
Just if I can reply on so 2 points in response to that. One is that I think that you can sort of distinguish their relationship, that they're not sort of roommates or that it's not an employee relationship, because you wouldn't necessarily expect roommates or employees to celebrate Thanksgiving or Christmas in the same way that the Wrights did here. And then the second point to that, I would say, is that if you do look to RHM versus Hampshire, which is this court's case, they did have very similar circumstances to the Wrights, and they were given succession rights. And in RHM versus Hampshire, they didn't have intermingled funds, they didn't share expenses, and they were still given succession rights. And the court overturned the Supreme Court's opinion, which said that they couldn't have succession rights because they didn't have this financial interdependence. And the court said because of their emotional connection, they found in favor of them and they gave them succession rights. And we would say that because of the connection between Dwayne and Janet and Horace, that they are entitled to this. And we would say that Janet and Dwayne went above and beyond for Horace and did things that only family members would do. Starting from the beginning, they left their home to move in with Horace and take care of him 24/7. And Dwayne was like a 15-year-old high school kid, and he, rotated Horace in his bed.
I hate to ask this, Ms. Perry, but obviously this comes to us as an Article 78. So there's already been an administrative proceeding which we're somewhat constrained by, which I don't have to tell you. Somebody had a hearing, the hearing officer, Ms. Lippa, I believe, and she went through all these different factors, and this is what she relied upon. So to overturn it, it's really a very high burden that's added to everything else on this, obviously.
And Ms. Perry, just very quickly, I just, disagree with you regarding RHM, because there was some type of financial connection between the tenant and the occupant. Certainly in that case, the tenant did provide money to the occupant. And I'm not sure if we have that here. In this case, we don't.
I just want to touch on that point quickly because I think it might be something that the respondents also touch on. We went back and closely read the lower opinions to make sure that we're able to speak on that. And what happened there was that the financial connection between them in RHM was that apparently the occupant, they had an agreement where she would give him 10% of her art sales. And actually the Supreme Court discounted that as actually being anything. And so, we would submit that actually their relationship, that they relied upon each other for the common necessities of life. And that's probably stronger than saying that, I'll give you 10% of any art sales, which the Supreme Court said, might not even actually be something.
Okay. Thank you, Ms. Perry.
Yes.
Let me hear from HPD.
Good afternoon. May it please the court, Mackenzie Fillo for HPD. This court should affirm the Wrights had the burden of proof and HPD rationally determined that they failed to meet it because they did not present any evidence at all of financial commitment and interdependence. I would like to speak very briefly about RHM, the case my colleague is relying on heavily. In that case, not only was there evidence that the tenant gave money to the occupant when he needed it, but
he paid
I
the
think
rent. I'm looking at the case. Also, apparently he paid the rent.
I believe there was financial connection, but I would also like to just correct. I think my colleague is misdescribing the procedural history. In fact, this court reversed appellate terms decision, which had reversed Supreme Court's decision. So this court actually reinstated the fact finder's decision and said that it was entitled to deference because there was some evidence in the record supporting it. And that, of course, is also the case here. HPD's assessment of the evidence is entitled to deference. There is the record more than supports the assessment that the petitioner simply did not meet the burden here. There are many ways a petitioner can prove what they have to prove here. Joint bank accounts, that they are the beneficiary of a 401k or a will, that they help pay the cable bill or the phone bill, that they buy groceries or furniture, that they share credit cards. They presented literally no evidence. They had counsel before the agency. They knew what they needed to prove. They are the ones who know what they provided to the household. If any of this information was in their favor, they would have put it in the record, and they didn't do so. And
well, the fact that, what is her name, Janice, right, was taking care of him, Janet, excuse me, could that not be seen as, an exchange of services? I mean, she's taking care of him, so therefore she is providing that type of service, which is a non-employee-employer relationship. But does that not mean that she is, to some extent, contributing to the household?
The record seems to show that she was providing this service and that the tenant's son was therefore paying her part of the maintenance. That's more like an employment. She was basically working for the son to take care of his father. And in exchange, she got housing. That's not a family relationship. The HPD reasonably determined that that kind of evidence is insufficient to meet the financial connection to prove a family status. And that determination is entitled to deference from this court. And certainly, we understand that the petitioners are complaining that they had limited resources, but there are many cases where people had limited resources and they can still provide something. They have some evidence. There's a case where someone got SNAP benefits and they used those to help buy household groceries. And you don't even have to have that. If you are really 100% dependent on the tenant of record, then that person, if he's really your family, should make some effort to take care of you after his passing, which the tenant did not do here. And that really speaks volumes about the fact that they were not family.
Well, perhaps that was because the tenant thought that they were family, and so therefore there would not be any issue.
Counsel, I just want to go back to that argument about the limited resources, because I don't recall them making that argument below.
That's
that
right.
Limited resources prevented them from contributing.
Yeah, they did not make that argument to the agency, and this court doesn't really even have, I think, discretion to address it, therefore. But even if the court did want to address it, there are many cases showing that impoverished people can meet the standard here. Basically, the petitioners are trying to write out of the rules the financial requirement, and that would just really open the floodgates and make it impossible for all the people on the waiting list for these apartments. These apartments are scarce resources with thousands of people waiting for them. And the petitioners here just did not prove that they're entitled to skip to the front of the line.
Thank you, Ms. Philo.
Thank you.
Let me hear from Riverbend.
Good afternoon, Your Honors. May it please the court, David Troop for respondent, Riverbend Housing Company, Inc. There is not much more to add to what counsel for HPD just said. And frankly, what the court was saying in its questioning. Yeah.
Let me just ask you, was Dwayne or Janet in the income affidavit of Horace?
So what the record reflects is that I believe Dwayne and Janet were both on the 2013 income affidavit, but that Dwayne was not
not on the 14.
Right, and I believe there was no 2015 income affidavit submitted. That's my recollection of what's in the record.
Okay.
So, but even still, you know, even if both were on the income affidavits for each year, still the financial interdependence simply has not been met. And as has been noted already during this argument, the hearing officer is entitled to deference. And this was really a complete and thorough decision by the hearing officer. The hearing officer addressed each of these points regarding the emotional connection as well as the lack of a financial connection. And the hearing officer found that this was much more of a caretaker type of arrangement. This is very clearly a decision where there was a rational basis. And also, just very briefly, I believe that counsel for HPD was also correct about the RHM precedent that that this court reinstated a lower court ruling, and there is no precedent cited by the appellant for what they are asking this court to do here, which is to overrule the Article 78 determination, which upheld the hearing officer's decision denying succession rights because there was no financial interdependence. There is no precedent for such a decision.
Thank you, Mr. True. Okay, Ms. Perry, you get 1 minute.
Thank you. I'll just run through these points quickly. Just with respect to the RHM point, I just revisited quickly the opinion. It does mention rent, but it does say that he lived with the occupant for 15 years without paying rent. So that case is still limited to the 10% art payments.
It also talked about
as
celebration of holidays and birthdays. Did you present any affidavits from neighbors or friends about their knowledge of them spending holidays together and going on vacations, things of that sort?
We presented affidavits from Janet and Dwayne and from Norman Travis, who is Horace's son. Because Horace is 91 years old, they didn't go on vacations. In fact, he wasn't able to leave the house. But we did speak at length about birthdays and holidays and celebrations.
But not
with
many
respect
neighbors
to
or friends, right? Or other family members, right?
No, just Horace and, Norman, his son. With respect to the economic resources argument opening the floodgates, as Ms. Fillo mentioned, this is already a point of law. And so I can't see it opening a floodgate if it's already mentioned in Park Terrace versus Offner, which is this court's case. And this was mentioned below, and this isn't a new legal issue. It's just a new argument on appeal. So I do think that this is something that can be considered. And I'd like to touch on her point that has been made repeatedly in the briefing, that the rights are skipping to the front of the line. They moved in and moved out of their home and moved in with Horace. And they lived in this home, for 10 years now and for 5 years before Horace died. And it's really quite unfair to characterize them as trying to skip to the front of the line, whether or not you agree with their arguments. I don't think that's the right way to characterize them. And the last point on, okay, thanks very much. I appreciate it.
Thank you so much. Thank you, all three of you.
Good afternoon.
Okay.
Thanks.
Last case is 3032 West 31st Street.
Yes, Your Honor, saving the best for last.
Hotel.
Yeah, good afternoon, Your Honors. May it please the court, Michael Schoenberg for the appellants, cross-respondents, the Hina Hotel defendants. The court has admitted my colleague, Mr. Edward Chang, a member of the Bar of the Commonwealth of Massachusetts, to appear pro hoc vice. I request that he be permitted to argue this appeal.
Of course. Welcome to the First Department, Mr. Chang.
Thank you, Your Honor. Just a quick point of clarification. I believe I have 6 minutes, 5 minutes for the argument and 1 minute for rebuttal. Is that correct?
That's correct. And so does cross appellant.
Thank you, Your Honor. So this case is about the proper distribution of proceeds from the sale of the hotel. The hotel, which was developed between the parties of this case. The hotel was sold and the money distributed, and now there are.
We're familiar with the facts, Mr. Chang. Can you please tell me why summary judgment disposition is warranted in this case?
Yes, Your Honor. The reason is, with respect to the substance of the case, they don't have an expert witness. The reason I was setting it up by saying that this is an accounting case is the trial court described it as an accounting case. Mr. Impagliazzo, who's the plaintiff, described it as an accounting case, and we agree this is an accounting case.
But hasn't plaintiff already quantified the net profits that were obtained by defendants upon the sale of the property?
No. And the reason, Your Honor, is because the plaintiffs, on their best day, is entitled to a share of the net proceeds. And that's all over everybody's briefs. That's an important phrase, net proceeds, because calculations must be made to determine what the net proceeds are. Net proceeds take into account the capital contributions of the parties, loans, the amount spent, et cetera, et cetera. So the plaintiff, in their case in chief, must prove their share of the net proceeds that they say they're entitled to. And the conventional way is to have an expert witness, that is someone who just sits there, looks through all the documents and says, okay, this amount goes to here, this amount is properly determined to be capital contributions, et cetera, and this is how the division should be finally done. In a typical case like this, you will have a battle of experts where there are two experts and then they start to identify what the certain amounts of money really are in dispute. In this case, they tried to have an expert witness, but that expert witness was stricken by Judge Cohen on July 11, 2019.
So you're saying basically that it is incorrect to assert that plaintiff already quantified the net profits that were obtained from the sale of the property.
That's correct, Your Honor. And because their argument, so the gist of it is, we have to figure out the net proceeds and then figure out the allocation from there, okay? Typically, it's done by an expert witness. Their expert witness is gone. So they argue,
Isn't the dispositive issue, you say typically, is it required though? Or is this something that can be done without expert testimony?
And that is their argument, Your Honor. And their argument is, well, if you have a competent percipient witness who can put the case together, that's sufficient, okay? In this particular case, they have said Mr. Impagliazzo. The only problem is Mr. Impagliazzo has already testified that he and his company were, quote, kept in the dark on the financials. And that's the record, page 1928. He also admits that he was a plumber, not an accounting expert, same citation. He even says that, gosh, I may be entitled for anywhere between $0 to $10 million. I don't know. And that's on the record 1133. And in the reams of papers submitted in this case, there's not a single coherent calculation by the plaintiffs of what the monies they assert should have been allocated to whom and to where. We are the only party that has done that, and that is our expert, Mr. Ash. And that's the fundamental problem of their case. They don't have an expert and they don't have a competent recipient witness. I don't even see how they're going to put in their case. That's why, Your Honor, summary judgment is appropriate. The second point is with constructive trust, the court imposed a constructive trust upon the assets of NCLB, which is an unrelated company, which has nothing to do with this project. Now, it's a matter of black letter law in New York, and Bertoni v. Catucci is right on point. It says an equitable remedy such as a constructive trust should not be imposed unless it's demonstrated that a legal remedy is inadequate. Your Honor, this is a simple division of money case. The calculation, while it's complicated, there is a damages remedy should, either party lose, and money is fungible. And frankly, a constructive trust is inappropriate under these circumstances. And it's really being used more as a substitute to an attachment. But the plaintiffs were not able to meet the requirements of an attachment, and so they went through the route of a constructive trust. But again, the constructive trust is inappropriate here because there is a legal remedy. And the First Central Financial Corp case, that's a Second Circuit case, 377 F 3rd 209, makes it clear. Look, when there's a contract dispute, there's no grounds for an equitable trust. All right? And all because a remedy is, if there's a remedy that's available, whether or not it's perfect or imperfect is irrelevant. The fact that there is a damages remedy available means that a constructive trust is not appropriate.
Well, but Mr. Chang, aren't you arguing that their damages claim ought to be dismissed because they can't prove damages, so then they won't have a damages claim? Isn't this there just in case that happens? Look, they may have difficulty proving their claim. I grant that, but Judge Cohen found that, look, let them see what they can do at trial. That'll be considered, and if not, then I'll move along. But he found that there could be a way that they could prove it, notwithstanding the loss of their expert or the striking of their expert. And so if in fact they aren't able to prove their damages, then wouldn't they be able to have an alternative form of relief available? And shouldn't we leave that in for that purpose?
Judge Kapnick, I think the answer to that question is the Judge Cohen, I think, should have taken the next step, which is to say, okay, what is their alternative? And their alternative that they have articulated is Mr. Impagliazzo himself. And we had submitted to the trial court, and it is before your honors on the record. He says he doesn't know what was going on. He openly says I could be owed anywhere from $0 to $10 million, and that he was kept in the dark as to the finances. I think the second step of the analysis is what's missing from Judge Cohen's decision, because I understand what he's saying. He's saying all because you don't have an expert doesn't by in itself close all the avenues. And I'm saying, okay, that may be true, but then what is the plaintiff offering in the alternative?
Okay.
With respect to the
I'll give you an extra 20 seconds, Mr. Chang. We're way over your 5 minutes.
With respect to the constructive trust, that's only, again, if there is a damages remedy available as a matter of law, which is different from whether or not the plaintiffs are able to sustain their burden of proof. Because as a matter of law, there is damages available as a legal remedy, they're not entitled to the equitable remedy of a constructive trust. Thank you, Your Honor.
Thank you, Mr. Chang. Let me hear from Cross Appellate.
Yes, may it please the court. My name is George Sava, and right off the bat, this is not as complicated as Mr. Chang would like to make it sound. The bottom line is we know that there was $14 million in profits made. Everything with regard to the split of those profits is based on contractual interpretation. So what is Mr. Chang saying? That the expert now has to become an attorney and he's interpreting the contract? What realistically happened is the accountant, their expert, was given a specific set of facts based on their client's interpretation, and then he rendered a decision based on what is owed on that that interpretation.
Is that an established fact that the net profits are 14 million?
It is an after the mortgages and everything else came off and fees were paid back and everything else, there was $14 million that was listed on the closing statement as the profits.
So then you actually say, well, it becomes then an arithmetic issue by playing that profit within the contract obligation or dispensing of the various shares, right?
That's correct. The contracts then dictate how money is to be then split, how that money is to be then split. But you get into, and if I could quickly get into what realistically happened here is that the defendants decided they wanted out. They wanted out of the hotel business. They told the plaintiff that the bank was forcing it, but there's absolutely zero evidence that the bank ever said you had to force the sale. What then happened is they used sale proceeds to secure another investment without telling the plaintiffs that they were doing this months before the sale, mind you. So they testified they knew exactly what they were going to get from the sale. Mr. Kandu Patel testified, I knew what we were going to get from the sale. And months went by. They knew exactly they were going to take every dime of it from day one, but they constantly and fraudulently kept telling my client, your money's protected, your money's protected, your money's protected. The closing date is in this date. They moved up the closing date. Then they took off to India for months and then said, we're not giving you anything. So in terms of the constructive trust in securing the proceeds from the sale, they meet those qualifications and they meet the law with regard to the fraud aspect and everything else. It's not, I look at this case and it's very simple. Money was made. How much are my clients entitled to? And what are these false promises that were made months in advance? And specifically things that were critically important to whether my client would even agree to the sale that they lied about. So they would ensure that my client would take specific actions to ensure the sale went through so they could take $12.5 million and immediately transfer that out to secure another property. So, clearly we met these areas, but at the same time,
and you say you don't need an expert for that.
I'm saying two things, Your Honor. I'm saying in terms of the split on the property, there is a contract interpretation. The other thing is with regard to how that was done under the law, and I cited the cases, we can still utilize their expert with regard to some of the math equations. And moreover, their expert says, I still think some money was probably going to be owed to the plaintiff.
And that includes the selling of the property at a loss in order to invest in another venture.
Now, the selling at the property there's two things there. So there was my client sold his property at a loss to support the venture to allow it to go forward.
Right.
And then defendants, basically, they determined what the price on the sale of the building was going to be when they were forcing the sale and telling these statements that the bank was forcing it and failed to ever justify that. Okay. So now you have this retaliatory cross-claim or counterclaims by them, one of which is seeking $45 million, saying, oh, we're entitled to all this money and you didn't build it quickly enough. But my guy wasn't the contractor. And they themselves testified that they have suffered zero damages in this case. They said they knew exactly what they were going to get. They said they knew they were being covered and every aspect of that. So how can you sit there and assert fraud and all these other counterclaims while at the same time saying, yeah, but we weren't damaged?
Okay, thank you, Mr. Sava.
Your Honor, so the $14 million profits, our experts sat down and took the time, and it took a fair amount of time to figure out and allocate how the $14.9 million should be allocated, out of which a lot of the money went to various loans, to repaying loans. The bottom line is the project was going downhill very quickly at the end, and they had to get emergency loans. Those loans had to be repaid. And so that's part of the dispute, and that's why our accounting expert accounted for it.
But whether the I believe that they were loans, oral loans, right, made to defendants. I mean, are those loans reflected in any documents?
I don't recall off the top of my head, but There were monies
Well,
coming
I
in
believe
from
that they were oral, but the question becomes, why do you need an expert to determine whether the loans in fact were made, whether you in fact had to repay certain loans? I mean, that's why I started by saying that it seems that plaintiff already quantified the net profit. So I hear Mr. Sava saying, well, that sounds like an arithmetic issue based on the contract. So
Well,
why do we need Mr. Cheat for?
Because, Your Honor, the profit, because Mr. Sava, my brother is saying that he's taking this is the entire reason we do need an accountant, which is Mr. Sava, the lawyer, is saying that there's a certain thing that he calls a profit. The net profit is something that is the calculation, which also includes paying back of loans, et cetera, et cetera. And the treatment of these loans and so on needs to be all put together to determine what the net profits are. If you look at the reams of papers for the plaintiffs, there is no statement that shows how they would want these monies treated. They don't just tell you. It's one of those people, they just try to poke holes, but they're the plaintiff. They have to say, well, gee, after these calculations, this is what I'm owed. And they fail to do that.
Well, that's what they'll say at trial.
Yeah, that's where you have trials. That's right. I mean, I assume you're going to have your accountant there, your expert, testifying as to how he does the division pursuant to the contract. And that person will be under oath and on the cross-examination by Mr. Sava. So we'll see what comes out. So you're talking about weight of the evidence. You're not talking the requirement for us to, or for the court to adopt one particular version as a matter of law. And that's really what you're asking us to do.
No, what I'm saying, what I'm suggesting, Your Honor, is that the plaintiff, looking at the order of the witnesses in the trial, the plaintiff has the burden of proof, and he doesn't get to put our witness on. I mean, it's our witness, and we can choose to put him on or not.
Well, that's the trial. If you choose not to put on an expert, then that sinks Mr. Sava's case. I mean,
right.
But again, that's to be determined at trial, right?
Right. And then it becomes, you're saying that that's your witness, but if he's going to be testifying, what's the evidentiary prohibition of having Mr. Sava call him as a witness? That's a dispute for the court to use. That's a discretion for the trial court to use at that time. I'm not going to purport to tell the trial judge how to do his evidentiary hearings.
No, yeah, yes, Your Honor. But I think my point is that at the end, if plaintiff is already saying, right, if the position right now already is the plaintiff does not have an expert witness, right? Before I have to put on my very first witness, okay, there is a motion to dismiss or a motion for directed verdict before I have to even start my case. And he's unable to, because he has neither an expert nor a competent witness as a matter of law, because there is literally no foundation for Mr. Pagliazzo, right, by his own testimony, that there is no damages case there.
But I heard you say that he could still prove his case without the expert. So again, I don't understand why, we could make that determination as a matter of law. I don't see why it would simply not go to trial. And then if in fact he can't make out his case, then that's it.
Well, I don't want to beat a dead horse, Your Honor. If I can just jump back to the constructive trust issue.
I'll give you 30 seconds on that because we are way over.
I apologize. The one of the key cases I'd like to point out that my brother cites to, which is U.S. versus, I think it's Powell, in support of his constructive trust argument. In that particular case, there's a very special rule for public officers, and this was a congressman, that says if a congressman takes money that belongs to the public, a constructive trust automatically springs up to the benefit of the government. That obviously doesn't apply here. The other case that he cites to, and of course I am blanking on the name at the moment, that is the, the Beatty v. Guggenheim, that is the seminal case on constructive trust. That's a situation where the employee took off with a business opportunity of his employer, and that's part of that business opportunity was put under a constructive trust. In this case, the NCLB development had nothing to do with Mr. Impagliazzo, and he never had any rights to that development. It's completely distinguishable from Beatty v. Guggenheim. Your Honor, we just ask that you dissolve the constructive trust. Thank you.
Thank you, Mr. Chang. Okay, Mr. Sava, you get 1 minute.
Thank you, Your Honor. Three quick points. One, I think what counsel is asking would set an extremely dangerous precedent where any breach of contract case where profits are involved would require expert witnesses for every one of them. With regard to NCBL, Your Honor, the Patels testified that they have numerous companies within the family. They throw money willy-nilly to these companies. Basically, they're all treated under the same umbrella, and they're essentially all treated as one. So to sit there and say that it's a completely separate entity that has nothing to do with one another, well, I go back to their testimony. Their testimony, yeah, we'll put one money here, we'll pull money here, we'll do this. It's all under the same umbrella. It's the Patel family at the end of the day. And the last point I'll make, Your Honors, is the late fee argument. They were charging $150,000. They took out $1.5 million in what they called late fees at the end. Those late fees weren't justified on any costs per month or anything like that. They were penalties. And they testified that they were in fact penalties. And under the law, that cannot stand. So they weren't entitled to that $150 right off the top at closing. And with that, unless there's any questions, I will cease, Your Honor.
Okay, thank you, Mr. Sava. That ends Appellate Division First Department session for the day. Good night.
Good night. Thank you.
Thank you, Your Honors.
Thank you, Your Honor.
Thank you. Good night.